Police say this video from inside the Dogwood Bar in Nashville, Tennessee, shows the beginning of an encounter that would end with 2 people dead and a 3rd man wounded. According to investigators, a fight over a woman spilled out of the bar and onto the street, where Clayton Beathard, 22, and Paul Trapini, 21 years old, were stabbed to death.
I think it was such a shock to everybody that this could actually happen.
These were good boys, and they were defending their friend.
Clayton Beathard was a standout college athlete and played most recently for Long Island University. His coach tweeted, "His love of life, people, especially his teammates, was a shining light on our program." Clayton's brother, C.J. Beathard, a backup quarterback for the San Francisco 49ers, took to his Instagram account to write, "Clay has the biggest heart of anyone that I have ever known." Paul Trapini III was captain of the high school football team. He attended Rhodes College in Memphis and was exploring law school before he died. The accused killer is Michael Mosley, and he's been charged with 2 counts of first-degree murder.
There is absolutely nothing that Clayton Beathard and Paul Trapini and AJ did to bring this on themselves.
Prosecutors say Mosley has a criminal history that includes this 2017 assault captured on surveillance video. Police say Mosley went into this Nashville Walmart looking for someone. When he found her, he knocked her to the floor and attacked her, kicking and punching the woman repeatedly. When customers started to approach, Mosley ran from the scene and out the front door. He was later arrested.
Somebody just hit me in the eye. So, I lost my sight and I was covering in it. He started throwing me and kicking me.
This is Molly Baker. She says he stabbed her in the eye with a key during the attack. Police suggest Mosley attacked her as payback. She and her husband are accused of murder in the shooting death of Mosley's stepbrother in 2016. Mosley was free on bond and facing criminal charges in connection with the attack when the fatal stabbings occurred. Mosley's defense attorney says his criminal past should not play a role in the murder case against him and believes video evidence will show his client was defending himself.
A person has a right to defend themselves if they think that they are in danger of serious bodily injury or death.
While Mosley remains in jail until his trial, friends and family members mourn their loss.
Lord, thank you for Paul and Clay.
And a survivor waits for justice.
Let's bring in criminal defense attorney Daryl Exum, Riverside, California, and law professor at the University of Georgia and former prosecutor Melissa Redmond. She's in Atlanta this morning. Good morning to both of you. This case is another one of our self-defensers. We're on a roll here at Court TV, where defendants are trying to convince jurors that they acted out of self-defense on some level. And Daryl, in this one, video is going to be a huge part of the case. The defense says if you really look at the video and the witness testimony, that there's a case here for the self-defense. What comes to mind to you first blush when you look at just the facts of this case and maybe the pitfalls for both sides?
Well, for the defense, I think the real problem is going to be in a self-defense case, you can defend yourself with deadly force against deadly force, and I just don't see that in the video, and that's going to be a real problem for the defense. Also, his history. That video of him in Walmart will not leave the jurors' minds when they're trying to decide what to do with this case.
Does it come in, though, and should it come in, Melissa, the incident at the Walmart the year before, because it, as Daryl says, I mean, that's a game changer. As soon as you watch that, you're like, uh-oh, we've got anger issues, and this guy's, he's in a different class when you look at this video, is he not?
He is. I think that is going to be relevant if the prosecution can get it in. I believe there will be pretrial motions about that. But the prosecution will be looking to establish that he's a primary aggressor in this incident. And I think an incident like that, him seeking out someone to assault unprovoked, is something that the prosecution would love to get into if the judge allows it.
Do you put him, self-defense, usually you have to get up there and explain, but Daryl, to your point earlier, he's got a knife at a fist fight, and that is, you just can't do that unless you really think that your life is in danger. And to convince a jury that you think your life is in danger, do you have to take the stand if this grain, because the video is not that clear?
And I think it's obvious that if he has to testify, he would testify because he has to make self-defense. Self-defense is, the difficult thing about self-defense is that it is in the mind of the defendant. And unless there's overwhelming evidence, defendants have to take the stand. And in a case like this, he will have to explain why he believed he was under an imminent threat of death. Now, the problem, of course, is once he testifies, what we, lawyers like to say, and Melissa will tell you, opening the door to his priors, because he can be impeached with his priors, but also the prosecution will, as Melissa said, attempt to get it in to show some kind of prior scheme, prior planning, motive, along those lines, some other alternate thing, not to show he's a bad person, but to show who he is under one of those other areas.
Victims in this case will be front and center as well. We anticipate right out of the gate with the openings. Melissa, how does that factor into any case where you have real sympathetic victims, young men whose lives were cut so short?
I mean, we tell the jury that they're not to base their decisions on sympathy, but it does play into effect as to whether or not they feel this was a justified homicide. The fact that if the narrative is that the victims were good people, good boys defending their friend and doing nothing wrong, and otherwise upstanding citizens, then that is certainly something that the jury will want to, it makes the jury want to do something about what happened to them.
Daryl, does it matter if the defendant didn't initiate the fight? That yes, he may have reacted with the deadly force that's unwarranted, but let's say at the end of the day, a juror does believe that these two and their other friends started it and were beating him up, and it was 2, 3, 4 against 1. Does that factor in?
Certainly it does, but to the first part of your question, and I think you have to understand that you're not allowed to initiate a fight, then use deadly force. That's not self-defense. You're not allowed to do that. So if he didn't initiate the fight, and if the fight was initiated by the other side, and then he used deadly force to protect himself, and the jurors don't believe he went overboard, he would have a defense.
Yeah, but difficult, Melissa, and that's the part of it that's difficult is the fearing for my own life, convincing, especially years later when it's clear your life wasn't in danger. Yes, you can feel fear if you're being beat up, but getting someone over that hump, how do you think, when we look forward, we're expecting openings later today, what do you think we're going to hear from the defense in the opening statements to try to get jurors in that sort of mindset?
The defense is going to have to put the jurors convince the jurors why he believes that fear was reasonable, right? So he can have a subjective fear that I'm going to get beat up, I'm going to get seriously injured, and I need to defend myself. But it has to be a fear that the jury is willing to accept as reasonable under the circumstances. So he'll have to talk about whether there's a difference in size, the number of people he was confronted with. I do think he's going to have to confront the fact that he initiated the initial confrontation, right? Even if the victims started the physical fight first, if he initiated that initial confrontation, that's something that he's going to have to explain, I believe, and bring the jury onto his side.
Daryl, Jan Norman is the prosecutor in this case. We watched her in the Waffle House murder trial a few months ago. She's very deliberate and can be very emotional during her presentations. What are you expecting from the state today?
I think the state is going to really make it clear that this was unjustified. And I think, if the state is smart, one of the things that they would bring up is what's called improper self-defense, meaning that, in fact, it's not perfect self-defense in some states. And in Georgia, it's called not a perfect self-defense, meaning he doesn't get away with murder, but he might get mitigated to a manslaughter charge. And I think if the state is smart, especially in a case where it's 2-on-1, no matter how good the victims are, the state will make that argument at some point, that worst case scenario, it's imperfect self-defense.
Is that a win, Melissa? Anything lesser than murder?
I'm sorry, I didn't catch any. I can't hear Gerald.
Oh, no problem, no problem. Just he was talking about the lessers and possibly the argument that this was an imperfect self-defense scenario. That's a win, is it not, for the defense if at the end of the day they get anything less than the top charges?
I agree. Yes, absolutely. Anything that they can show to say, well, maybe I'm not justified in the homicide, but my actions were mitigated in some way, to get something less than that first degree would definitely be a win for the defense.
All right. Again, we're expecting jury selection to begin at the top of next hour. And then as soon as the jury is seated, it'll be time for opening statements. This will be our next live trial here on Court TV. Still